individual. The judge went on to state, so even while accepting that the 49(1)(f) may in certain circumstances and contexts, the ruling is pursuant to an application that was brought before this court on the 17th of November 2025 by a notice of motion, application of even date. The orders that were sought by the applicant were that the respondent be detained at the Anti-Terror Police Unit for a period of 20 days at the ICD police station within Nairobi County to enable the applicant conclude investigations, and secondly, that the applicant be allowed to forensically examine and analyze the electronic devices that were seized from the respondent as particularized in prayer number 3, support to terrorist groups, collection and provision of property and services for commission of terrorist acts, facilitation of terrorist acts, and financing of travel to for terrorism purposes, among other offenses. The respondent is an advocate of the High Court of Kenya, which, according to the investigators, preliminary investigations have confirmed and disclosed that the 2 mobile phones received monies from Binance account linked to an individual who is designated by the United Nations Security Council, ISIL, in bracket Daesh, and Al-Qaeda Sanctions Committee on the 16th of June 2025. That preliminary investigations therefore indicate that the respondent may be transacting with terrorists, designated entities, in contravention of national and international targeted financial sanctions, hence the need to grant the orders sought herein to safeguard the integrity of the ongoing investigations. The respondent is also suspected to be linked to a network of terrorist recruiters, which is responsible for recruiting both Kenyans and Tanzanians for terrorism, and which consists of terrorist actors from several countries, including Somalia, Tanzania, Kenya, South Africa, Zambia, and Congo. Hence, the investigations cut across borders and may require cross-border collaboration and mutual legal assistance, which are time-consuming processes and which necessitate sufficient time to be granted to the investigators. Due to the sensitive nature and the national security implications of the ongoing investigations and the need to ascertain the extent of the damage occasioned by the alleged activities, release of the respondent at this initial stage of investigations may jeopardize the efforts to arrest accomplices who are still at large and the preservation of evidence for crucial witnesses, including the respondent's associates and colleagues, which is yet to be collected. That the need to ascertain the respondent's fixed abode to conduct further searches in his place of residence may also be jeopardized should the respondent obtain an early release from police custody. There are legitimate questions which bear on public safety and national security, and as such, I find that the instant application demonstrates compelling reasons that merit the detention of the respondent at the preliminary stage of this investigation. In the end, therefore, I find and hold that the present application has merit and it is hereby allowed accordingly. The respondent shall remain in custody for 14 days, during which period the investigations will be ongoing. The said period will be tabulated or will run from the 17th of November 2025 when the respondent was presented before this court. Prayer number 3 of this application is equally merited and it is granted as prayed. That is the ruling of the court.